Our chair for this session is Vicky McInnes. Vicky McInnes is lecturer in art in the Victorian College of the Arts and coordinator of the Master of Fine Art and Visual Art program there. She's worked at the VCA since 2005 and was director of Margaret Lawrence Gallery until 2015. In 2009, with Kate Barber, she established Sarah Scout Presents, a private gallery committed to representing and developing opportunities for early to mid-career artists with critically engaged conceptual practices. She's also co-founder of the Contemporary Art Fest Spring 1883 and is currently undertaking a PhD at the University of Melbourne, considering contemporary feminist art practice and the archive in Australia. Before I hand over to Vicky and to introduce our speakers, I'd just like to note a trigger warning for this session: sexual violence and harassment. Thanks so much, Vicky.
And thank you, Kyla. Thank you for the warm welcome and for the invitation to speak today and to introduce this really stellar panel. I'd like to acknowledge where I am, which is on the unceded lands of the Yalukit Willam clan of the Kulin Nation here in the South Bank campus of Melbourne University. Hot and steamy unceded lands as they are today, and pay my sincere respects to the traditional custodians and to all First Nation friends and colleagues who are joining us today. It's been really fascinating to consider the subject of consent over these past days across so many disciplines and discourses: colonial, medical, technological, interspecial, to name a few, legal, as we'll continue that discussion today. But especially as someone who works primarily with visual artists, and it's an absolute pleasure to be here for the final conversation, which is on bodily autonomy, and to precede Luke George's performance, which will conclude the forum. As a woman, as a feminist, as a mother, I have specific concerns around consent, of course, and like most of us, I've been both reiterating and renegotiating these ideas for decades. However, the space of art has always been one that can test ideas and push boundaries in ways that operate outside of other orthodoxies and frameworks. And over the last week in particular, I've been thinking about some of the artworks that explore consent that continue to resonate with me. Works that refuse consent, like Sophie Cahl's remarkable Suite Vénitienne from 1979, for which she followed a man she'd met at a party to Venice, phoned hundreds of hotels until she found out where he was staying, and followed him around Venice, even persuading a woman who lived opposite his hotel to let her photograph him from a window. Work like Tracy Moffat's Heaven of 1997, in which she similarly flipped the male gaze by surreptitiously filming boys getting changed after a day's surfing, or work that challenges the public versus private context for consent, like Danny Marty's 2010 video portrait of the art collector and patron Peter Fay. The work Bacon's Dog documented Fay having his first ever sexual experience in his mid-60s with the artist. Or Andrea Fraser's 2003 Untitled, for which an American collector paid $20,000 US to have consensual sex with the artist, and thus become part of the video work documenting that encounter. So many tough, profound, unsettling works that straddle some of the legal and social aspects of consent that this panel will be tackling today. And of course, it's not my job to talk about art, but my happy job to talk, to introduce our speakers today. And we are beginning with Dr. Bianca Feilborn. Bianca is a DECRA Research Fellow and Senior Lecturer in Criminology in the School of Social and Political Sciences at University of Melbourne. Bianca, I'm going to hand over to you now to share your screen and take us away today. Thank you.
Great, thanks so much, Vicky. Okay, I'm just going to get my slides up. There we go. Hopefully everyone can see that. So I'd like to start by acknowledging that I'm joining you from the stolen and unceded lands of the Wurundjeri people of the Kulin Nation. I'd like to pay my respects to elders past, present and emerging. And given that we're talking about sexual violence today, I think it's important to acknowledge that First Nations people, and particularly women and brother boys and sister girls, are disproportionately impacted by sexual violence, though I would also like to acknowledge the resistance and the leadership of Indigenous communities in relation to this issue. So today I'm going to be reflecting on the issue of sexual consent in terms of how it's treated under the law. And in the 10 minutes that I've got, I'm going to briefly examine some of the proposed reforms to Victoria's sexual offences legislation and the similar reforms that have just been passed in New South Wales relating to affirmative consent. And I'm going to argue that although these are seemingly positive initiatives on paper, in practice, they are unlikely to actually have the desired effects in practice. And instead of the emphasis on law reform and how consent is conceptualised under the law, I'm going to suggest that we instead need to be looking towards alternative measures for addressing and redressing sexual harm. Okay, so to start off with, how is consent actually treated under the law at the moment? So I'm focusing specifically on the Victorian context here. There are, similarities and differences in different jurisdictions across the country. So I'm going to simplify this to a great extent. So any lawyers that are here, please feel free to send me cranky emails later. But in general, there are three really key elements to sexual offences in Victorian legislation. So the first is that a sexual act actually occurred, and that is typically not contested in most trials. The second is that this sexual act took place without consent. And this is really key here. Consent is the crucial factor that separates legal from illegal sex. And also important to note, because I think there are still misperceptions that sexual assault and sexual violence must involve some kind of physical force or physical violence or active refusal from the survivor, and that's not the case under the law. So yeah, the complainant or survivor is not consenting, but the third kind of key component is that the accused or the person who's caused harm did not reasonably believe in the survivor's consent. So how this lack of consent is actually established is currently quite problematic in terms of what happens at trial. So, for example, it means that survivors often face quite extensive cross-examination about their own behaviour in order for the defence to show that they, in fact, were consenting, even though they are saying that they were not. This often involves the defence drawing on rape myths and misconceptions. For example, the notion that survivors, and particularly women, will routinely lie about having experienced sexual violence. They're often questioned in detail about their own behaviour during the incident and so forth. And it's for this reason that we often see the court process and the trial, particularly cross-examination, as being referred to as a second rape or as a traumatic process in and of itself. Likewise, we also see the accused or the defence drawing on some quite problematic understandings about sexual consent. And again, this is actually despite the fact that, where's it gone? Under the current Victorian legislation, we actually already have a communicative model of consent in practice. So this means that consent is seen to be a free agreement, and that not saying or not doing anything means that the survivor wasn't consenting. So consent is conceptualized as being a process that requires quite active and ongoing communication in theory. So we see the accused person or the defence in trying to establish that they had a reasonable belief in consent, drawing on some problematic misconceptions and stereotypes about women and about how consent is negotiated. So for example, some Victorian research by Dr. Rachel Bergen from Swinburne, where she analysed rape trial transcripts, showed that the accused was drawing on ideas around, the survivor was dancing near me earlier in the night, or, she put her hand on my knee earlier in the night, and that these interactions were seen as sufficient for the defendant to have a reasonable belief in consent. And I would suggest that that is inherently at odds with this communicative model of consent. I think importantly, under the current legislation, while any steps that are taken by the accused person in ascertaining consent can be taken into account, in determining whether this belief was reasonable, they're not actually required under law to have taken any tangible steps to make sure that the other person was consenting. So this means that their reasonable belief can be established without actually having done anything to confirm that belief. And as you can imagine, that is quite problematic and leads to some of these arguments based on an imagined belief in consent. So in Victoria, the recent Victorian Law Reform Commission Sexual Offences Inquiry has recommended that Victoria moves towards an affirmative model of consent. And as I mentioned, New South Wales has recently passed similar amendments. And it's my understanding that the Andrews government has committed to introducing an affirmative standard of consent in Victoria. So what does this actually mean in practice? So I think quite similarly to the communicative model of consent that's already in place in Victoria, consent is again based on a free agreement between the people who are involved in a sexual encounter, and it involves active and ongoing communication. So this includes verbal communication, but also gestures, sounds, and so forth. And again, it's based on this understanding that someone who is consenting to sex will be actively participating and communicating that consent. So importantly, under these reforms, an accused person who wanted to argue that they had a reasonable belief in consent would now actually have to show that they took some steps to ascertain this. And certainly this does create a higher onus on the accused, particularly for cases that are centering on the question of whether they had a reasonable belief in consent or not. So currently they don't have to show that they took steps. Under this new legislation, they will. My slides are being very slow, sorry. So I think this all sounds fantastic in theory, and as I said, yes, it does to some extent create a higher onus on the accused. However, I have some real concerns around how this will actually be implemented in practice. So I think firstly from a legal perspective, the prosecution will still need to establish that the survivor wasn't consenting. And unfortunately, I think that this means we will continue to see similar defence tactics in terms of implying that the survivor was lying, and potentially even a heightened emphasis on the behaviours and actions of the survivor at trial. Secondly, it's currently unclear what actually constitutes a step. So what will be the threshold or the standard of behaviour that is actually expected of an accused person to show that they took steps? And will that necessarily reflect the standard that we're perhaps hoping that it will? It's unclear at this stage whether Victoria will include instructions or examples of what counts as a step, or whether there will be certain requirements introduced in the legislation. Thirdly, I think we will unfortunately continue to see the same evidentiary challenges, even with this increased onus on the accused person. So for most sexual offences, these are occurring between two people who have known each other in some respects. Usually they're not contesting that some form of sex has occurred. They're contesting whether it was consented to or not. Because of the nature of how most of us engage in sexual interaction, these are things that happen in private. There's rarely other forms of kind of tangible evidence or witnesses to what's happened. So these cases tend to hinge on one person's word against another, and whose version of events is seen as being more credible. And unfortunately, I don't see these affirmative consent revisions as overcoming those evidentiary challenges. Fourthly and finally, from a legal perspective, we don't know yet how these provisions are actually going to be interpreted and applied in practice. And we have seen, for example, with the last round of Victorian sexual offences reform in 2015, which were similarly heralded as being quite progressive, that they weren't actually applied or didn't have the impact that we were really hoping they would in practice. So more broadly, outside of the law, I think there are some concerns with this concept of affirmative consent. So firstly, it is quite individualistic in nature. So by that, I mean it's really only taking into account or focusing on the actions of particular individuals, in the context of singular sexual interaction. And affirmative consent doesn't really acknowledge how our actions or the ways in which we engage in sexual practices might be shaped by broader social and cultural norms. So, for example, we know that people often submit to sex that they don't want or that they might feel ambivalent about, and their partner would probably quite reasonably believe that they were consenting from a legal perspective. So, for example, for cisgender heterosexual women, we know that they're often socialized to be compliant and polite. And this can make it incredibly difficult to say no or to express openly your sexual wants and desires. So sex under these circumstances might be unwanted or harmful, but it actually couldn't be addressed through this affirmative consent under the law. So in other words, the law doesn't consider how we might be constrained in expressing our sexual desires, wants and needs, and how that might be shaped by our various intersectional structural positions. Finally, I would also suggest that affirmative consent in a lot of respects actually sets quite a low bar for what's expected of us in a sexual encounter. So certainly, at least according to the legal approach, it is, encouraging open and ongoing communication, which is fantastic and a great starting point. But it doesn't actually require that sex is ethical, that it's pleasurable, that it's mutually desired, and so forth. So I would suggest, particularly in our everyday sexual practices, that we can perhaps aim a bit higher than an affirmative standard of consent. So I know I've probably already gone over time, so I just want to flag very quickly in closing that instead of continuing to return to the law as a site of change, although I'm not suggesting we entirely abandon law reform as a project, but nonetheless, I think we have seen repeated rounds of sexual offences law reform in this country, in some cases quite progressive reforms that just haven't had the impact that we thought they would in practice. So rather than continuing to return to the legal system and expecting it to give us a different result, I suggest instead that we need to be considering some more innovative and creative alternatives. And I think that includes, firstly, efforts to actually generate the transformative social and cultural change that's required to address those structural factors that are underpinning sexual violence, but that also shape our capacity to, consent to sexual acts in that individualistic way. Secondly, I would suggest that there is a need to develop and implement innovative community-based responses to sexual violence and other forms of harm if and when it does occur. So I think there are some potential promising avenues for this, such as restorative and transformative justice, which tend to centre more on articulating the harm that's been caused by someone's behaviour and emphasising the safety and healing of the survivor, and holding the person who has caused harm to account, ideally without perpetuating other structures of power and injustice. And particularly in the case of transformative justice, seeking to destabilise the structures underpinning the violence that's occurring in the first place. But finally, I'd suggest that there's also a need for creativity and innovation. And I think we need to be bold in developing new and progressive responses. And I'll leave it there. Thank you.
Well, thanks, Bianca. Gosh, so many issues raised and so many complex questions opened up, and certainly the idea of evidence in this context is very perplexing. I wonder if the next generations will be better equipped to deal with the issue of consent, as it's an issue that is, absolutely privileged, albeit controversially, within sex and health education in schools at the moment. And I'd certainly love to come back to the idea of consent futures later in our discussion. But let's jump into our next presentation, which is by Professor Beth Gaze from the Melbourne Law School at the University of Melbourne. Professor Gaze teaches and researches in anti-discrimination law, including harassment, so we couldn't be in better hands. Thank you, Beth. I'll hand over to you now.
So I'd like to begin also by acknowledging that I'm speaking from the unceded lands of the Wurundjeri people of the Kulin Nation, and to acknowledge their elders, past and present. And I'd like to thank the organisers for inviting me to talk about this, because of course sexual harassment is incredibly topical at the moment. So it is a very interesting area to talk about. And what I'm going to talk about is to slightly change the context from what Bianca's talked about. So I'm going to talk about the way consent is translated into sexual harassment law and what it reveals about the underlying unstated assumptions on which the law rests. So I'm going to do it by introducing you to the legal definition of sexual harassment, and then I'll talk briefly about what that means in practice, who actually experiences sexual harassment. And then I'll narrow in to look at the idea of unwelcomeness that the law rests on, and just trace out how it relates to pervasive sexual stereotypes in our society. And again, I'll conclude by suggesting some possible alternatives that underpin, I think they can be seen to underpin some of the work that, for example, Kate Jenkins is doing in relation to the current federal parliamentary law reform. So let's begin. So the definition of sexual harassment I'm going to talk about is the one in the Sex Discrimination Act, which is the federal law. And all of the other laws in the states and territories are pretty similar to this one. They've got slight variations, but this is the sort of main definition. And there's two main components. So unwelcome conduct of a sexual nature in relation to the person harassed, which includes an unwelcome sexual advance or unwelcome request for sexual favours, or making of a statement of a sexual nature in the presence of the person. So notice the emphasis on unwelcomeness here. And then secondly, so the conduct element has to be proved. And then secondly, there's an evaluation of that conduct. And the evaluation has a couple of elements. So it's circumstances in which a reasonable person, so that's an objective assessment, a person who's observing from outside, having regard to all the circumstances, would have anticipated the possibility that the person harassed would be offended, humiliated or intimidated. So that is a subjective standard because they're considering what would be the reaction of, what would be the possible reaction of the person, the actual person who's harassed. So it's quite a complicated test when you unpack the language, but it's stood the test of time. It's been around for about 40 years, so it's done what's really necessary. What we notice about the first component and the conduct component is the focus on the sexuality of the person being harassed, of the target of harassment, and the fact that it requires proof of unwelcomeness. Now, so the definition is one thing, but then what about the way in which it's enforced? So the way in which it's enforced is because it's a civil provision, the only person who can enforce it is the person who's the target of harassment. And so who is that target of harassment? So in 2018, the Human Rights Commission published the data from its 4th National Survey on Sexual Harassment in Australian Workplaces. And this was a very good survey done with a national representative sample of 10,000 respondents. And it disclosed sort of fairly horrifying statistics. So 1 in 3 people reported experiencing sexual harassment in the last 5 years. Younger people were at the highest risk. It was higher in male-dominated industries. And one of the shocking statistics was that in information, media and telecommunications, it was 4 out of 5 people had experienced it. The majority of harassers, but not all of them, are male. Of the people harassed, only 17% complained to their employer, and of those who had complained, half said nothing changed as a result. And with bystanders, 2 in 3 people who witnessed the sexual harassment took no action as a result. Now, this National Inquiry report landed at the same time as the whole Me Too process emerged in the United States and then moved to Australia. And the government provided some funding to the Human Rights Commission to carry out a national inquiry into sexual harassment in the workplace. And so that was undertaken in 2019 and 2020, was published by the Australian Human Rights Commission about a week before the COVID lockdown occurred. So unfortunately didn't get a lot of attention then. I've got a further, on the next slide, I've got a slightly more detailed breakdown of who actually experiences harassment. And I think this is really important. So the impact on vulnerable groups is the thing we need to acknowledge. So nearly 40% of women experienced it, 2 out of 5 women, only around 1 out of 4 men, so a quarter of men. But of the more vulnerable groups, over half people in LGBTIQ and Aboriginal and Torres Strait Islander groups experienced sexual harassment. And for people with disability, it was nearly half. And it was more likely for lower income earners. So we can see that this is being targeted to the people who are least powerful in the workplace. Okay, so that's, and this is just the table is just a graphic representation of those statistics. So the question is, how is this law enforced if enforcement rests entirely on the person targeted, and it tends to affect the people who've got the least power in the workplace? So just to remind you that that national inquiry found that less than 1 in 5 people complained even internally to their employer, let alone externally to a legal agency. And of those, half claimed nothing changed as a result. So why don't people bring claims? Well, they might be afraid they'll lose their job if they complain. They may have, the harasser might be their employer or their supervisor. They might want to preserve their professional reputation, not to be the person whose sexual harassment claim comes up every time someone does a Google search about them. They may not expect it will change anything, and that looks like it would be fairly reasonably based. Alternatively, they might just want to move on and not have it dominate their life. They might think it's easier to just go and get another job. Alternatively, the legal process might be a real disincentive. So if you actually do raise one of these claims externally, if you raise it internally and the employer process is not satisfactory, then you go to an external complaint and it can't be resolved through negotiation. The enforcement under the Sex Discrimination Act is that you have to litigate in the federal courts. And if you lose the claim, you can be held liable to pay the costs of the other side. So, and often if you're suing, say, a government department or a large employer, they will have spent a lot of money on legal costs. So this is a very risky process to take on board, and it's not surprising that very few people feel able to. And so that does raise the question of what's the value of the law if it's difficult to enforce? So it can't be We can't necessarily regard it as an instrument of enforcement, but we can regard it as symbolic, that it sets a social standard. But we might also ask that question, how can we make this law a bit more effective? So I realise this is a slight diversion from my topic, so I'm going to show you one more addition to the definition, and then I'll come back to the idea of unwelcomeness. So this is a provision that was added to the definition in the Sex Discrimination Act in the last couple of years. And it provides that the circumstances that can be taken into account in assessing the sexual harassment include the intersectional factors such as age, sexual orientation, gender identity, religious belief, race, colour or national or ethnic origin, disability of the person harassed, or the relationship between the person harassed and the person who may be advanced. You know, are they someone with power over that person? So these might identify greater vulnerability and power disparities in the relationship between the two people, which is quite helpful. I have to say, so far, there's no particular indication in the case law that the courts have taken up this opportunity to actually identify sexual harassment as being based on abuse of power rather than sexuality. Okay. And so very recently, in the last couple of months, we've seen the changes that have come in as a result of the Australian Human Rights Commission's report in 2020 on respect at work. And so the definition has been expanded now to include a new category of harassment based on sex. So that's not about the sexuality of the person, it's really trying to catch misogynist harassment, in other words, harassing someone because of their sex. However, the amendments are not fantastic because there's a very high threshold to make this out. So to succeed on that limb, one would have to show that the conduct is seriously demeaning. And that will be a high threshold. And so it is quite possible that it will be quite difficult to make out that claim. Okay, so returning to the idea of consent in sexual harassment law, this is expressed in terms of unwelcomeness. So what does it mean? What's the role of unwelcomeness here? And the courts have said the test is subjective here. So it's whether the conduct was actually unwelcome to the target of harassment, but she or he has to communicate this to the person doing the harassing. But failure to do that communication, in other words, failure to object, is taken to be consent. So it's a positive obligation on the target of harassment to establish that it was unwelcome. And of course, there are many reasons why someone may not object, as outlined above, you know, fear for your job, etc. They can give the appearance of consent, and it's not explicitly dealt with by the law, but decision makers need to be sensitive to this, to the role of power imbalances and their impact. The law, I think, allows it to be argued, but doesn't make it explicit other than in those provisions I just showed you, that this is actually something relevant to assessing unwelcomeness. So how does this sit against the idea of consent in sexual assault law? So does it echo the requirement in sexual assault law to prove lack of consent? In a way, it's not a one-to-one correlation, partly because sexual harassment law only applies in limited circumstances in what we regard as, quote, public areas of activity. So in the workplace, in education, provision of goods and services, in other words, in the marketplace, and so on, provision of government services. But also it's the distinction between civil and criminal laws. So in sexual harassment, the claim is brought by the person harmed, not by the police. The rationale is compensation or restoration of their position rather than punishment of the offender. Sexual harassment law only addresses this on an individualised basis, so it focuses on compensation, and there's no mechanism for general deterrence. The deterrence is presumably to be through the fact that people can see that the harasser gets penalised and they don't want that to happen to them. And then, of course, proof is on the balance of probabilities, not beyond reasonable doubt. But that still doesn't affect the problem that sometimes this conduct can occur with just two people present, and then inevitably it's going to come down to an assessment of credibility of both those people to work out what actually occurred. But that is eased by the fact that the proof is balance of probabilities rather than beyond reasonable doubt. So what's the role of unwelcomeness in sexual harassment law? So as in sexual assault, it makes the target of harassment responsible for communicating no to the harasser. And it draws on and reinforces dominant sexual stereotypes in our society. So there is active male sexuality and active male pursuit, and passive female sexuality and passive female acceptance or rejection of an advance. The unstated presumption is there is always acceptance unless she acts to make the rejection clear. This is clearly inappropriate in a workplace or an educational situation or provision of government services. So that presumption of consent unless unwelcomeness is made clear is a problematic issue in this area of law. So some legal decisions actually do sort of depart from the insistence on unwelcomeness and pretty much say, look, there's a standard of reasonable behaviour at work, and if you breach that, then you'll be liable for harassment. So in sexual assault law, we've just heard Bianca talk about the moves towards requiring affirmative consent, but comment that the implementation of this will still be very challenging, partly because we are dealing with judges who all have presumably some degree of these dominant stereotypes underpinning their ideas. So just to conclude, what's the way forward in terms of sexual harassment law? So one of the things that I think is really important and has been over the last couple of years as changing our cultural understanding is that we are now starting to hear the stories of targets of sexual harassment at work or in education as a result of the work of many people. So Me Too's been very important in that. And leading people like Grace Tame and Brittany Higgins. Also the work of the Equal Opportunity and Anti-Discrimination Commission, so Kate Jenkins' work on the Commonwealth Parliament. The Victorian Commission has been working hard on Victoria Police and Ambulance Victoria, so there's been a lot of reporting and analysis of how these organisations actually run and how to actually create a safe workplace, a non-harassing workplace. So we understand much better the impact of the powerlessness of the targets, and it's not just a trivial offence, it's a serious, significant harm that people experience. And we understand why sexual harassment should be understood as a product of power inequalities and not just of sexuality. So I'd suggest that probably the proposed movement in the future is towards something like positive consent, opting in, although even in these workplace situations, that's probably in a general workplace situation, really, I think we need to be moving towards an objective standard of what behaviour is acceptable in a context where everyone has a right to be treated with respect. And so, of course, that's sort of an interesting issue to see how far that gets in our Commonwealth Parliament based on Kate Jenkins' recommendations. So I hope that gives a little bit of a picture of the role of unwelcomeness and what consent means in the context of sexual harassment law. Thanks very much.
Well, thanks, thanks, Beth. As you noted, it's both topical and timely, this forum, and that was so fascinating. The discussion around unwelcomeness and the idea of a presumption of acceptance is just blowing my mind right at the moment, and we'll come back to that. But it was interesting to read the opinion piece by Julia Banks in The Age this week. Around coercive control in Parliament, which I guess is another, kind of extension of this conversation that we might also come back to. And obviously we know Parliament is a toxic workplace, as there are many, both public and private, and hopefully we can open up some of those conversations as well. But thank you so much. Of course, issues around cultural and public safety are paramount and persistent, and they're also something our final speaker will address today. Simona Castricum is a multidisciplinary creative and academic who works at the intersection of music and architecture. Simona is an educator and PhD candidate in architecture at the Melbourne School of Design, the University of Melbourne, and she's also currently presenting Sync, a live immersive sonic and spatial performance, which you can currently catch at Arts House in North Melbourne. Simona, I'll hand over to you.
I'm speaking from Wurundjeri country on Kulin Nation, and it's always a pleasure to do so, and I want to extend my respects to elders past, present, and emerging out there in the land of panels out there. So yeah, I think I'm what I really love about, I guess, the interdisciplinary context of this chat is that, like, quite often these chats are sort of really concentrated in like silos of the legal sector or the health sector or whatever, and it's sort of like really difficult for other people to get in on the chat, particularly if you're from like a marginalized background. And I use the word marginalized in terms of like a seat at the table. So I really appreciate this opportunity to chat, because like how I sort of work within architecture and music, I think presents a great opportunity to sort of break through that, to find the platform and to find the place to speak. But also I think a 5-minute pop song can reach and tell a story a lot better than an 80,000 word academic thing, you know, which is quite inaccessible. But you know, like my PhD, I think has been really great because, you know, it's really given me an insight to how consent and its relationship to permission is something that I've come to understand more definitively through my lived experience of gender transition. Because my PhD and my music is really from an autoethnographic, you know, methodology. But gender nonconformity in gendered spaces like all present risks to trans and gender diverse people, as cisnormativity imposes these very strict rules around what gender is in public space, and it constructs this apparatus of policing, of surveillance and interrogation. Where from like childhood, you know, it's like something that Judith Butler talks about, is that like from childhood we're all thrust into an assemblage of gender performativity. But for gender non-conforming people, this can often occur against our individual will to suit the expectations of the gender binary. So community, authority, administrative structures, carceral systems and morality are all these sort of like big things at play that put a lot of pressure on us. And I never consented to these cisnormative external coercive influences of gender. Instead, I freed myself from the gender binary when I granted myself permission to live authentically, rather than consistently or constantly seek permission from a world that would rather I remain invisible and silent. It's like, you know, instead of constantly trying to sort of like beg for crumbs in that sense, it's like I've just had to like set my own table up. And music and architecture has presented a site for me to do that. And I talk about, I guess, like music as a site of transing. But I never consented, I guess, to transphobia, this sort of scrutiny, the violence, the ridicule or discrimination that results from merely being trans in public space. And, you know, for me, it's, you know, when I think about it in terms of gendered violence, it's just a very different conversation for me. And it's a conversation I feel like I've been trying to have for quite some time, and really trying to get through like what the dominant conversation is. Like, because I'm just sort of like marked for the cisnormative apparatus to receive, I guess, you know, this transphobia. You know, I receive it every day, and trying to articulate it through music or through architecture has been a really interesting thing. And I feel like the thing that, you know, the image that articulates it best for me is this image. I find the airport one of the scariest places in the world. And I think a lot of people find airports incredibly scary because, and I guess this image really sort of tells it for me. This is the airport, and this is the security checkpoint at the airport. And it's a place where my body is scrutinized, my identification is scrutinized, the relationship that I have with law enforcement, with other travelers, you know, as a public space. This is a serious site of anxiety for trans and gender diverse people, but also like for a whole lot of people. And it's just like, well, to what extent have I consented my body and, you know, or my identification, I guess, to be scrutinized in the way that it is? It makes it very difficult to participate in public space in this way. you know, I liken it to the panopticon, you know, which becomes the architectural manifestation of the sort of transgender gaze, which is something that Lucas Crawford talks about, where surveillance and punishment become an inseparable consequence of gender variance. And I try and articulate these things through my music videos. So it's kind of like, well, this is my video for Nights Don't Breathe. And it's like, well, what is it like to occupy public space? Particularly after like you've had an incident where, you know, you have been subjected to violence, or you have been subjected to sexual assault or something like that. So my art practice, and how like I think about architectural theory and how I think about space, you know, is all about, I guess, trying to deal with these things and trying to get them, I guess, into the public conversation through music video or through releasing songs. I'm not the lawyer. I'm not the health expert. In fact, I'm not the expert. All I am is the expert in my own lived experience. So I guess to explain, like, architecture is a site of violence. So people experience architecture through typologies, so characteristics of form and space. So I guess that last slide of me sort of in the middle of, like, you know, downtown Los Angeles, you know, it's like a, you know, that's a pretty difficult site to be physically trans in. But just as each typology of architecture has its own iconography, it leaves its own unique imprint of experience and emotion. And when we associate these experiences with buildings or spaces, they become embedded into architecture. Secondly, there's the idea of architecture as administrative violence, where briefing, data, employment, and leadership uphold the gender binary that determines all design processes. So these systems become the very premise upon which all space is created. So trans people experience violence, exclusion, discrimination, ridicule, shame in very specific ways. And most often the perpetrators of street violence or intimate partner violence are cisgender. So cisgender male and cisgender female. So the framework of cisnormativity and heteronormativity renders the experiences of trans and gender diverse people as silent. And this is something that I'm really, really struggling with in the public discourse. So the public conversation around gendered violence can't continue in a vacuum of cisnormativity and heteronormativity if we are to understand the experiences of trans and gender diverse people, albeit all forms of gendered violence. Gendered violence is not a monolithic binary of male against female. The struggle against the cisnormative heterosexual patriarchy is our combined struggle, however. So my question is, why should trans and gender diverse people continue to bear the brunt of a system of control on their own, one that enforces a gender binary which actively harms trans and gender diverse people all the time? Accepting the systems that make cisgender rights to space more important is cissexism. It is inextricably linked to transphobia, transmisogyny, and colonialism. It also isn't being an ally. It's not an ally to just like rock up on Trans Day of Visibility or Trans Day of Remembrance and be like, all trans bodies are sacred, yet be a perpetrator of, you know, of intimate partner violence or of abuse, and not go into repair or accountability or anything like that, and just engage in performative allyship. That does nothing for the person that's been harmed. In fact, it just triples down like the harm that's happened. Trans and gender diverse people have more, however, to contribute to architecture and civic life than talking about their trauma in space or lobbying for a better bathroom user experience. Like, just do the thing. Our perspectives inspire exciting futures for gender and spaces for architecture and the worlds we live in. And getting back, I think, to something in the previous previous panel before, is like, you know, there's a song I sing called The Present, which is like, I'm sick of talking about my trauma at the conference on the panel, and I'm wondering if anyone's listening, because I'd rather just play techno. I would rather just play techno, but I feel as if I'm talking about this idea of gendered violence and wanting to open it up and how differently trans people experience it, like, yeah, I kind of want that to be sort of taken seriously, you know, and the sort of like, I've got to try and communicate that through the song, because it's like trans people are sort of like trying to, this barrage of stuff that's happening against us from the far right and from like conservative feminism, and it's just a really difficult space to occupy, and we're being forced into conversations that serve like the cis debate, but they're actually not the conversations that we want to have. I want good relationships with cisgender people, and I don't want contest or division. I don't want third spaces. I want inclusion for trans and gender diverse people in all aspects of civic life. Beyond permission, beyond diversity and inclusion, beyond my transness, if only I could be someone to you, then who would I be? Thanks.
Thanks, Simona, for such a personal and profound presentation, and the question of embodiment, but also carrying the burden of responsibility through this period is, you know, is one that is really critical in all of these conversations. There's a lot to unpack in all of the presentations, but and some questions I'm sure to come, but I thought I might just begin by suggesting that what we're seeing is an emergence of, I guess, a number of new feminist fault lines, as Simona just alluded to, around transphobia, around sexual harassment, and a lot of these fault lines are emerging through the discussions and the discourses around consent. For example, we saw in the wake of Me Too and Time's Up in 2018, the open letter written by 100 French women, including writers, academics, and businesswomen, which criticised the movements and defended men's freedom to pester. And of course, transphobia is rampant in public dialogues, in feminist dialogues, with Germaine Greer and others denying the right of transgender folk and insisting that trans women are not women. Simona, this intersects with your assertion that gendered violence is not a monolithic binary of male against female. And I wonder what you make of the recent celebratory cover story and photo shoot in the Herald Sun, of all places, of Danny Laidley last weekend, and the former North Melbourne football coach who was so shockingly treated by the Victorian Police, an institution which purports to uphold public safety. And her consent obviously was denied when, you know, last year when and violated. And, you know, be interesting to hear any thoughts you might have on that, based on your own discussions around, you know, that embodied way of being, you know, moving through these patriarchal and cis insistent structures.
Well, yeah, I mean, but this is the apparatus of transphobia that trans people are marked for, just simply by virtue of being trans. And this is the, you know, when the police are sharing photos, you know, of trans people who are incarcerated for lols, you know, like that's just such an indignity, and it's just such a breach of, well, you know, a complete breach of consent. But it's just like, but you know, it's like the report that came out a couple of days ago or a couple of weeks ago by was it Victorian Queer Rights Lobby. It was like, you know, it's like 4 in 5 queer people don't trust the police to use their discretionary powers. So police are kind of like using their discretionary powers, like, you know, against, you know, like the trans and queer community, you know, like it's a sport, you know, and they've been doing it, you know, for so long, you know, and we're only just sort of like getting to like significant inquiries around what's happening to all of the murders that were happening, you know, along in Sydney. So you know, yeah, I just where's the change? You know, I just don't know. It's it's difficult. I mean, I can't speak specifically to Danny Laidley's case, but I can speak generally. I think to just there is this huge mistrust that you know police don't make queer and trans people safe, let alone whether they're interested in you know, like what our needs are.
I mean, I think that's a you know, such an important question. Where's the change? And it goes back, I guess, you know, takes us back to the current, some of the current changes that are being proposed, at least, in the law. And Bianca and Beth, I guess, you know, a question to you both. You know, given that we do have affirmative consent laws, at least proposed to be taken to Victorian Parliament next year, you know, do you have a sense of how that might play out in terms of justice for victims of harassment and assault? I mean, it still seems that there's so much subjectivity around, you know, around the issues. Beth, did you want to, I mean, do you have a sense of where it might take us, of what the change might look like?
I mean, I guess from the point of view of sort of social change, I would just say social change is a really big task, and just changing the law doesn't change your social environment, and it doesn't suddenly change all the police, and it doesn't suddenly change who's on the courts making decisions. So it has to be seen as a process. And that's why I sort of referred to what's happened over the last couple of years in sexual harassment, because I think we've been for decades beforehand without hearing the experiences of victims of sexual harassment. So we haven't understood how harmful it is, how much they're constrained by circumstances, and how difficult it is to speak up and act against it. And so I think I take on what Simone is saying, that, you know, people don't understand what that experience is like. They don't understand what's going on in terms of transphobia. They might be completely unthinking about transphobia. They might be intentional, but I think the campaign to actually change that is really a substantial long-term undertaking. And every now and then, you know, a moment will come, like it came with the same-sex marriage survey, or like it came with Me Too and then the subsequent reports in Australia, and you have to take advantage of that opportunity as soon as you possibly can. But as to criminal law, I'll leave it to Bianca to comment on that.
Yeah, thanks, Beth. I mean, I think everyone is probably aware from my presentation, I am deeply skeptical of the ability of these reforms to generate significant change. Like I said, I think they will, you know, I'm very happy to be proven wrong on this, but my, you know, suspicion is that they will be taken up and, you know, eaten by the system. Like the system will continue to operate, you know, as business per usual. I think that, you know, defence will find some pretty quick workarounds for a, you know, a slightly higher, you know, burden on the accused person. So yeah, very, very skeptical. But also, as I said, it doesn't address any of these structural factors around how we negotiate consent in our sexual relationships. And in fact, I don't think the law can generate that sort of change. You know, I don't think we've seen, certainly not significant change in terms of the heteronormative and cisnormative framing of gender-based violence in this country. You know, if we look at the discussion and debate that's happened around the next iteration of the national plan, still being called the National Plan for Violence Against Women and Their Children. It's being framed in incredibly heteronormative terms. You know, where do LGBTQ plus people fit within that? For example, how do we recognise forms of gendered violence that are occurring because of ableism and racism and colonialism and all of these other structures? Like, they are literally excluded from our dominant conversations. You know, I think we have seen some shift. There was some, I think, fairly tokenistic inclusion of queer community in some of those discussions. You know, we are seeing some more research and public discussion, but overall, you know, I don't think there's been sufficient change. And what does it mean to talk about consent, for example, if your experiences of sexual violence are completely occluded from being recognised, you know, under our dominant frameworks? It's almost meaningless. You know, does consent apply to you if you can't make claims around your experiences? So yeah, I could probably talk for hours on this, but yeah, very, very deeply skeptical. And that's why I think that we have to be looking at these alternatives. You know, again, if the police aren't safe for you to go to, law reform doesn't make a difference, because you still can't access that system.
And that's one of the questions that's just been posed actually by Vida in the audience, who asks, does the police force allow for non-binary transgender people to be accepted into the force, and would change have to come from within? I mean, that's exactly what you're just talking about. I mean, you know, that goes back to that truism, doesn't it? We cannot be what we cannot see. And you know, as glib as it sounds, if we're not being represented in all our you know, public structures, then I mean, how does that change happen? I mean, you've suggested that it's and I think there's been suggestion from a few of the panelists that generational change is one aspect. And certainly, you know, I think my 14-year-old daughter has a far clearer idea about her own bodily autonomy, certainly than I did at her age, but probably than I even do now. And, you know, that's one hope, I guess, for our future. I am getting the hurry up, which I can't believe. As you say, we've got hours of conversation to have, but we have a performance that is due to take place in just a moment. But in terms of that specific question about the police allowing for non-binary and transgender, I don't know if anyone has a specific answer to that question, or about training, diversity training and awareness for police, which is also cropped up as a question.
If I could just very briefly
yes, please, Beth.
Because I teach anti-discrimination law, and the anti-discrimination laws, the legal system has recognised since 2013 that gender is a continuum and not a binary. So the social change follows very slowly. You know, it's the fact that law might recognise that partially, not completely, not in all areas, doesn't mean that everybody in society recognises that. So law, but if people find out about it, can have some symbolic effect. The anti-discrimination laws are being amended slowly to update the understandings of gender identity and gender performance and so on, so that they would protect a trans person who wants to join the police from discrimination. It would be discriminatory to reject someone on that basis, but it's a slow process of amending these laws. Yep.
Yeah, but anti-discrimination laws are a bare minimum, and they don't, and it's been proven over time that they don't actually really, you know, like it's so difficult to prove discrimination for a start. But like, are the police culturally safe? I would say anecdotally, no. I would say from the most recent reports that would come out, I would say no. You know, and also, like, cops are trained to do bad things. You know, so it's just like, you can, I don't know, like, yeah.
And from what we've heard recently, it's not that safe for women either. So I certainly agree with you, Simona.
Yeah, and just really quickly, because I know that we're short on time, but Yeah, so police do receive, especially new recruits do receive training on, working with LGBTQ plus communities. But again, we've seen, with that, but also with things like being inclusive of women, being inclusive of people from different racial and cultural backgrounds, that having greater training and greater diversity in the actual force, again, hasn't necessarily had the impact that we hope that it would in practice. Yeah, so it's not necessarily sufficient. Like, again, people tend to take on the norms and cultural attitudes of the police force. It's not to say that absolutely nothing has changed, but I think it's been minimal and certainly not to the extent that we would really hope. I've been involved in some research a few years ago now about policing of young LGBTQ plus people in Victoria. Certainly there were individual police officers that we spoke to who I think were like genuinely trying to be inclusive, and there was difference across the different sites. Some places were very overtly discriminatory and violent. Others I think were doing better, but the young people we spoke to in those areas still had horrific experiences with the police, still experienced overt transphobia in particular. So yeah, for me, I just think trying to generate that change within established systems is almost impossible. Like, I'm much more along the burn it down and start again kind of.
Yeah. And I think that's something that we can end this panel discussion on. There's quite rightly anger, there's despondency, there's also hope, and there's a hope that we're coming to the tail end of patriarchy, and that's the system that needs burning, that's for sure. Thank you to all three of you so much, Bianca, Beth, Simona. I wish we had days to continue the discussion. Kyla, I know you're knocking on the door, and it's been such a pleasure and an intense privilege to be here with you all and to be part of this forum. So thanks.
Thanks, Vicky. Trans women are women. Thank you.
They are indeed. Thank you.
Thanks, everyone.
We are going to close off now with a presentation by Luke George, a creative commission that we've been working on with Luke, called Risk and Intimacy.